The magic of an estate plan for a married couple. I'm Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. We assist folks every day in estate planning and the administration after a loved one's passing. If you need help in either of these areas here in New York or New Jersey, you can reach out to us for a free consultation at 𝘿𝑎𝑛𝑔𝑝lanningattorney.com. And speaking of value, we are also always here educating everyone. So drop some questions for us to answer, and don't forget to share so together we can help some folks along the way. Now, if you are a married couple and you own absolutely everything jointly, or you've designated your spouse as your beneficiary on insurance and retirement, which is common, you are correct in thinking there may not be very much to do at the first passing. However, if you wait to do your estate plan, that could cause some ramifications after that first passing. Now, why? First of all, if you do a proper estate plan, likewise, at that first passing, there usually is not any major upheaval or changes that need to take place, which is good and comparable to before you had a plan. But what is different typically at that stage? Their surviving spouse is grieving the loss of their partner. They are typically a little older, and they will have already established who their decision makers are in the case of incapacity and what their wishes are at their passing to secure the beneficiaries and protect them to the utmost way possible. Without doing so, that can easily fall through the cracks, and that surviving spouse will leave the rest of the family sort of in nowheresville. So having a plan done as a married couple, albeit not much of a change at the first passing, has a huge impact on everybody moving forward, including the survivor spouse. They have peace of mind that they're protected if they fall ill. They have their decision makers, and the directives between the partners for the future have already been established. Granted, the surviving spouse may choose to shift some things up if they are prepared to at that time, but they've been protected all along. In other words, we have clients, a widower, who come in and they say, I want my eldest child that was named as the next trustee to serve with me so that they can help on the bank accounts and the other financial transactions. We help assist with that. They might want to, if there's a change in the family, health dynamic, what have you, where they need to change their health agents, we can go ahead and do those things. But if those haven't changed, they're already established, there's no major concern, and they are protected. Without a plan for that married couple, also, there can be side consequences if the decedent spouse owned assets in their individual name. I covered this not too long ago in a recent video, but essentially, the beneficiaries are not automatically you as the spouse. Who knew, right? Without a plan, it goes according to state law. That may mean you and some children, either together, children you had together, children from a prior relationship, who knows? But it doesn't automatically mean the spouse receives that asset if it was owned individually by the deceased spouse. So keep that in mind. Your wishes are important and they need to be known, but also in proper legal written plan. So I hope you've learned something new here today. Again, Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey. If you are seeking assistance in estate planning or the administration after the loss of a loved one, you can reach us at 𝘿𝑎𝑛𝑔𝑝lanningattorney.com for a free consultation. Please take care and don't forget to share. Bye-bye.